people really know what DRIs are. And how do you explain that to lay people? What's DRI? So I Googled DRI. Anybody want to guess what the most hits come up when you Google DRI? Dirty, rotten imbeciles. No, Jackie, not those dirty, rotten imbeciles. It's a rock band. It's an indie rock band. Trust me, go Google it. I have three topics which I'm going to cover very briefly because you do have handouts. Let me start probably with the easy one, which is the consent agenda. This has been an issue which has bugged many of us for a very long time, and we have found this most recent commission for the last 4 years, 8 years, has really tried to abuse the consent agenda. I'm not sure how much of it is commission, frankly, and how much of it is administration. I have included in the handout, it's rather lengthy, but the entire current procedures, rules of procedures for the Martin County Board of County Commissioners. And the part about the consent agenda is number 4, because on the agenda of each meeting, the items under number 4 are the consent agenda items. Most people don't even understand what the consent agenda is. And I've given you a little primer on consent agenda from a nonprofit organization that explains how a consent agenda is supposed to be used. And quite frankly, what the Martin County Board of County Commissioners rules of procedure state is the purpose of the consent agenda. And that is to allow non-controversial items that are just going to take up time to be adopted by a single vote of adopting the agenda. When the commission approves the agenda, they have approved everything on the consent agenda. And the idea is usually 2 things. Things that are just non-controversial, don't really cost any money, accepting an easement from a landowner, very nondescript things, certainly not controversial. And the other area is something that the commission has already approved. If the commission has already approved a project, maybe an implementation matter could be put on the consent agenda. Other than that, items should not be on the consent agenda because there's no public discussion, there's no up or down vote. You don't know how each commissioner feels about the items because they don't tell you, they don't talk about it. Usually what I do is before each meeting I will send out a little email to everybody letting you know what's on the consent agenda. It's not at all unusual for there to be millions of dollars of expenditures buried on the consent agenda that taxpayers, you folks who are paying these charges, don't know anything about. Actually, when Charles Patterson was talking about the legislation, the legislative session, he mentioned that regional planning councils under new legislation are not supposed to be doing consulting because they were competing with private consultants. We had on the consent agenda not too long ago a $35,000 contract for the Treasure Coast Regional Planning Council to be a consultant and schedule some hearings on Martin County's new mooring and anchoring ordinance. Thank you, Commissioner Hurd, and thanks to Commissioner Fielding. We often are able to get these items pulled off the consent agenda, and that item was voted down as an unnecessary expenditure, $35,000, and the function was going to be to hold 2 public meetings on this ordinance. It ended up being done by the city of Stuart for about $3,000. The rule in Martin County is that any commissioner can pull an item from the consent agenda. So if you see something on the consent agenda, send an email to your commissioners and ask that they pull it. If a commissioner requests that the item be pulled, it will be pulled, and it will be given full public discussion. In the city of Stuart and in a lot of other communities, any citizen can pull an item. I'm a resident of the city of Stuart, and I can send the city manager an email saying, please pull item blah blah from the consent agenda, and it will be pulled. In Martin County, you have to get a commissioner to make that decision. So far, Commissioner Hurd and Commissioner Fielding have been very accommodating to public discussion and public disclosure of items on the consent agenda, especially those which involve large sums of money, which is quite frankly more common than not. Also contracts, things like giving the Maritime Museum a $1 a year lease at Indian Riverside Park. That was pulled off the consent agenda, had full discussion. That was unfortunately approved, despite the fact that Commissioner Smith never disclosed that he was the chairman of the board of the Maritime Museum at the time that matter came forth. In any event, read the materials, look at the rules of procedure. You'll notice, if you bother to read all the rules of procedure, you'll notice how many rules are violated all the time by the current chairman. One issue is the order of things. You know, for some reason, the current chairman takes great liberty in moving things around whenever he feels like it, probably because, you know, somebody is here sitting in the audience and he doesn't want them to wait all day to get to their item, so he takes my item and puts it on the bottom and takes their item and moves it up. Under the rules of procedure, that can't be done without a majority vote of the commission, but Commissioner Campy doesn't ever inquire. So there are other rules that you might just be interested in to take a look at. The agenda is available on the county's website. The agenda itself will be available fairly early on, but the individual items, which includes the consent agenda items, are not available until Friday before each Tuesday's meeting. But I would encourage you to go to the county website, familiarize yourself with taking a look at the agendas, seeing what's on there, and obviously making your opinions known. I want to move next to the wetlands issues, but I also wanted to comment on Maggie Berchala's discussion of fiscal conservancy, I think she said. We are absolutely sorely lacking in fiscal conservation among our commissioners. Golly, our money just gets spent without a second thought. I did notice that just this week, Martin County got a notice from the Army Corps of Engineers, I think it is, that we owe an additional $1.7 million on a project that we never paid our share on, and we were told, Martin County was instructed by the federal government to write a check for the I think it was $1.6 million by the end of the week. Don't know if that's been done, but check your bank accounts, people. That's where it's coming from. I'm looking for that letter so I can give you the exact amount, because I was kind of startled. But as I said, check your bank account. They haven't even asked anybody. I guess the engineering department's just going to cut the check. It's the Department of the Army, the Corps of Engineers. The total amount the check is supposed to be for is $1.634 million, which the Corps wanted paid by March 16th. This was a letter dated March 8th. So,
what's it for?
it's for when the Army Corps does a project with a local community, there's a split of the cost, and in this case it's a project that was previously done on a 47% federal and 53% local split of expenses. And there is an actual agreement that's entered into. This is for the Martin County Shore Protection Project. And apparently the work has been done. Martin County never paid its share. There was an in-kind credit afforded to the county in the amount of $916 for some in-kind work as opposed to just writing a check. But now the federal government wants its money and is saying essentially they're not going to go forward with new projects until they get paid the county share of this one. The engineering department has asked the legal staff to see if they can figure out how to get out of this. We'll see. Usually they don't ask, they just cut a check, our money. The other issue I wanted to talk about is wetlands. We have a new wetlands LDR. LDR, for those who don't know, is Land Development Regulation. We talk about our comprehensive plan. Our comprehensive plan is what we refer to as our Constitution. The comprehensive plan establishes broad policies and goals that our government strives to meet. The LDRs, the Land Development Regulations, are like the statutes or the ordinances that implement those policies that are set out in the comprehensive plan. Our comprehensive plan has said almost from the outset that it is the goal and the policy of Martin County to protect all wetlands. There has never been any deviation from that until this year when the staff proposed a new land development regulation that changed the ordinances that implement our wetlands protections to say that Martin County will protect delineated wetlands. Now the staff and the county legal department said it was necessary to revise our ordinance because of a change in state law. And it is true that there was a change in state law. It is not true, however, that the change in state law necessitated this change in our ordinance. The change in state law was simply to require all counties to delineate wetlands in the same way. Delineation means, for lack of a better term, survey. You establish the boundaries. You delineate where the wetland is by marking the boundaries. There are different types, different methods of delineating wetlands. There's one method of determining what a wetland is. It's based on the type of soil, it's based on the level of saturation, water comes and goes, it's based on the type of vegetation that naturally grows in that soil. That's what defines a wetland. The delineation determines the boundaries of the wetland. That makes sense. When the state law was changed, it was simply changed to say everybody has to use the same method of delineating. I can't say that a wetland goes out here because I'm using a different method than you say, and when you're determining that the boundary is here. So the only thing the state did was adopt a uniform method of delineating the boundaries of wetlands. Martin County staff, no doubt at the request of the development community, leaped on that as an opportunity to change our ordinance so that we now protect only delineated wetlands. The only way to delineate a wetland is to have a state or a county, a government biologist following the uniform method go out and physically delineate or use aerials and other methods to delineate the extent of the wetlands. This is expensive, it's time consuming, nobody ever does it. So if you don't have a delineated wetland, and the vast majority of wetlands in Martin County are not officially delineated, then under the new ordinance and under our county attorney's new interpretation, that wetland is not protected. I did a lot of legal research. I'm going to spare you going through the statutes and the regulations and the case law, but I'm confident that the interpretation that the county attorney has given is incorrect, that we still can protect all of our wetlands, whether or not they are formally delineated. One of the materials in the packet that you were given is the first part of a case called Johnson versus Gulf County out of the First District, bless you, Court of Appeals, bless you, you're welcome, that addressed this very issue a few years ago. That this was in, was it Polk County? Gulf County. In Gulf County, the comprehensive plan provided for protection of wetlands, whether or not there was no distinction between what's called jurisdictional wetlands. Those are wetlands that have been delineated and are within the jurisdiction of a water management district or the DEP. There was no distinction. All wetlands were protected. The developer had taken the same position that our county attorney takes, that says if those wetlands weren't delineated, if they weren't formally outlined by a state agency, then they're not protected. So the developer simply brought in a bunch of fill and filled in all the wetlands on his land. And he turned a very wet, very large parcel of land into a housing development based on acres and acres and acres of fill. The county challenged that, and it ended up in court, and the court agreed with the county that its own protections of wetlands did govern. You can't just bring in fill, throw it in the wetlands, and then say, not delineated, no wetland. And that's what that's what they had done in the Johnson case. So I think there is legal authority, there's statutory authority that says whether a wetland is delineated or not, it can and should be protected. Martin County has abdicated that by passing this new wetlands ordinance. And gosh, we can only hope that we get a new commission in place that can undo that and restore our wetlands protection for all wetlands.
I don't know if you know this or not, but did Mr. Johnson have to remove the fill?
Mr. Johnson, I think, was actually the...
He was the appellant.
He was the appellant. He's actually a lawyer. Not all lawyers are bad. He's the one, hey! So, yeah, they did. They had to restore it, which is extremely expensive. Yes, they had to restore it. He hadn't gone all the way in his development. He had put the fill in, but he had to restore it. Thank you, Lawyer Johnson. And the last thing I have is a little more lighthearted thing, how Martin County citizens ate their way to the best place in Florida. Not talking about this really nice spread. Thank you, Conservation Alliance, for a really nice spread. I'm talking about words that end in ate, A-T-E. And I just want to go through them really quickly. Most of you know them. A lot of you practice them, but I'm just hopeful and encouraging all of you to practice all of them all the time. First one is associate, which is what we're doing here today. Associate with people who think the way you do, who have a passion for things you have a passion for. Associate, get together, and make your voices heard. The next one is another educate. Educate yourself first. That's the old thing about, you put on your life jacket, save yourself first, and then save the others. Educate yourself. Find out what's going on in your county. Look at the consent agenda. Look at the ordinances that are being proposed. Educate yourself. Gosh, the internet is such a wonderful educational tool. Get on there, and my favorite legal search engine is Google. I Google everything. So you have a question, Google it. Unfortunately, maybe we could call it Google-ate, but educate yourself, and then educate your friends, and educate your family, educate everybody you come into contact with. Here's Jackie, Transinger's favorite, pontificate. Go up to the microphone and tell them what you think. Don't be afraid to speak up. Communicate. Pontificate and communicate. Tell people how you feel. And if those of you have a little stage fright and aren't comfortable with the microphone, I will send you Jackie Transinger's email. Here's a really important one, folks. Donate. That's one of the biggest 8s we have. Put your money where your mouth is. But it doesn't have to be money. Donate your time. Donate your ideas. Donate your thoughts. Donate your work. But don't forget that biggie. Donate your money. Write a check when you can to whoever you want, to whether it's one of your associations, to whether it's a political candidate. Don't forget that is one of the most important 8s we have. The last one is my personal favorite. Don't like to do it, don't want to do it, but if you got to do it, litigate. Thank you, folks. You all are